we are expecting few more students to join the link because they have, I think, some lectures or practicals or some project work. They'll be a little delayed, I guess. But we can start. Strength is good enough. This is 5:16. As per plan, we were supposed to join at 5, but because of certain unavoidable delays, we are here at 5:16. We are going to start the program. Please, sir, with your permission, may I start?
Yeah, yes.
Yeah, you can unmute yourself and talk.
Yeah.
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 Ma'am, I'm just saying that if some students are yet to join, we can wait for 5 to 10 minutes. That is okay from our end.
Okay, 5 minutes. Maybe students will go on joining continuously. Meanwhile, we'll have the Zoha. Can you mute while joining? There is a beep sound. Can you check in setting? There is something you can have the adjustments.
Yeah, ma'am.
Yeah, every student when joining, we get a beep. It creates, see, that's a nuisance. Can you check that? Pooja madam, you will be sharing certain PowerPoint presentation or something?
Yes, ma'am.
Would it
I'll be sharing. Yeah.
have intellectual property rights and management of all these intellectual properties? Budding engineers will be exposed throughout today's session what is IPR basically and how do we manage when we have the IP. So we are having with us Mr. Swapnil Kulkarni. He is owning the company Magic Prints and they are typically involved in 3D printing, engineering design and analysis service and intellectual property rights filing. They are, his qualification is he's basically BE mechanical. He has additional certification of Six Sigma and he has several years of industrial experience at his credit. He'll be sharing some IPR related issues today. I mean, he'll be participating in your question answer session as well. We have the next expert for today's session, Pooja Menon madam. Her qualification is BTech Information Technology. She has done diploma in IPR and she has some certification courses from central government IPR institute we have in Nagpur. And she also has several years of industrial experience with her. So we are happy to invite you. You are here. So I think we can start the session immediately. I request. I welcome everyone and Pooja madam, I would like to hand over the speaker position to you. Please go ahead.
Thank you, madam. Thank you for the warm introduction. And I wish everyone a very happy World Intellectual Property Day. We feel really happy when people are taking initiatives these days to at least spread what IPR is, how teach students and faculties what IPR is on such a even taking the opportunity on World IP Day. So, not wasting much of your time, I'll just share my screen so we can start with the presentation. And today we'll be learning about what IPR is, what are the bifurcation, how you as an individual can benefit from it. See, if you're ever investing even 1 minute of your day, or like here you're going to invest like an hour or something, so you should know कि आपको क्या benefit मिलेगा. Like once you have attended this as a person, as an individual, what is the benefit that I'm going to get from it? So that is, after today's session, you will have a lot of benefit with respect to the future education that you're going to opt, multiple scholarship offers, better job opportunities. All this will revolve around today's session. Okay, so let's begin. So basically, there are two types of IPR. There are two types of property. One is called the physical property. Other is called the intellectual property. Now, physical property we all are very well aware of, like the land you purchase, the home you have, the vehicle that you drive, the gold that you buy. All these things are called physical property. Now, if you ask anybody, like, what do you have? Like, तुझे किस बात का गुरूर है? तेरे पास क्या है? right? So anybody will come and tell you that, I've got so much money, I've got so much land, I have bought so many car, and I have so much land with me. So that is what people try to always convey to somebody when they're bragging about their wealth, right? So since a very young age, we are very well taught that if you want to build a physical property, you have to work very hard, you have to work hard, earn a lot of money, and then buy something. And you have to be always protective about it. Like, suppose if you decide to purchase a house, you will file it under the government, have a property paper for it, and then you will decide to endorse it to anybody that you want to. So that is all about physical property. Now let's understand what intellectual property is. So anything that is created in your mind is intellectual property. It does not have to be, physical property. It does not have to exist in your hand. It's just in your mind. It's intellectual. It is called intellectual property. So all the ideas, creativities, paintings, poetries, all these things are called intellectual property. Now, see, as I told you, we are very careful when it's a matter of a physical property, right? Suppose you invite me for a cup of coffee, and I'm like, you know what? I love your home. So let's do one thing. You all can pack up your bag and just leave. From now on, I'll stay in this place. Can I actually do that? No, you won't let me do that, right? You'll actually show me your property papers and drive me out of your place, right? So that is the power of having a government legalized documentation. Now let's talk about intellectual property. We are very careful about our physical property, and we are very casual when it comes to the matter of our intellectual property. Now suppose, think you're working on a project, or maybe you're working on research work, and suddenly you have a eureka moment, and you suddenly realize that, oh my god, this is something that, if I invest into, I'm going to earn a lot of money out of it, or maybe this can change the direction which people have been thinking about this concept. So you have got an idea, but the thing is, we are never confident when it's just a matter of an idea. We want an assurity from someone whom we think is intellectually competent. So as a normal human, as a very everyday type of human, if I get an idea, I'll see to it that I share it with somebody I trust. Maybe I'll give a call to my colleague, or maybe to a person whom I, maybe a guide or someone like that. See, the biggest problem is intellectual property. We all experts have a theory that intellectual property has a shelf life of a banana, an open banana. So suppose I, decided to share the idea with somebody, and he or she decided to just go ahead and publish the paper, or give a call to media people, and start discussing the idea that this is what I have got, or I have published a paper on this, and I'm such a genius. How can you go and stop that person if somebody decides to take your idea and to publish it as his or hers? See, when it was a matter of your home, you had the property papers to prove your ownership. But when it was just a matter of an idea, although you have worked months and years to get that, to reach that idea, still it did not take 1 minute to get it copy, to somebody to get, copy it. How can you stop that person? So this happens with so many researchers in India, right? So many people have their projects copied, or the research, violated by people around them. This is very common tendency. Just to stop this, just to protect the intellectual property, government came up with a scheme, a facility that is called intellectual property rights, IPR, under which patenting, design, copyright, trademark are the four bifurcations which are majorly help you to protect your intellectual property. Whether it's an idea, whether it's a design, it's a structure, it's a monument, it's a painting, it's a poetry, a brand name, anything can be protected, which can be commercialized or converted into a product in future. So that is IPR. Okay, so let's understand each and every category one by one, and let's start to link all these things with everyday activity of yours. You need to think that how copyright is related to you, how patenting is related to you, what can you patent, what can you copyright throughout the session. If you have any doubt, please just write it down. Towards the end of the session, we'll have a personal Q&A for it. Okay, so the first topic that we are discussing is copyright. Now, copyright is very simple. Copyright helps to protect a artist or an author's right. That means many of you might be good in your academics, but there is something that you decide that you love to do apart from your academics. Like many of us might be good painters, maybe poets, we write books, write papers, create softwares, do paintings. Now all those things are called your can be protected under copyright. Now people usually come to me and they're like, you know what, why to protect a painting or a poetry that I wrote? See, for you that might be just a hobby or might be something that you did just to pass your time. But just imagine, there is a mass public, there is a huge population in the entire world that earn from their creativity, right? There are so many artists across the world. So there is a need to protect their art of any kind. Okay, so that is where copyright comes into picture. So the second question that usually I get from the public is that, suppose I wrote a paper, or maybe I clicked a photograph, or maybe have just painted something. Why do I have to file a copyright? I can, this is the generation of social media, I can just publish it on my any of my social media account and people will come to know that I did this work. See, now this is a misconception. Imagine you decide to publish something onto your wall, okay? And there is a timestamp that shows on which date and what time the content was published. But it does not prove that the work was created by you, neither the date of creation of the work. Now suppose I'm surfing through the internet and I find something interesting about Bill Gates, okay? And he had quoted something or he said something and I loved the way he said it. So I decided to just copy that content onto my wall, okay, onto my social media account. Does that mean I have written it? In any case, can I prove that I wrote those things? No. It is already somebody else's content. I just decided to publish it onto my wall. So in such circumstances, it can be clearly proven. So there is no proof that I did that work. On the other hand, when you file for a copyright, the entire content is submitted with the registry. So what happens is that the government provides you with a timestamp, a certificate approving the ownership of the work, and the date on which you file for a copyright is the date of creation of the work. So anybody decides to publish a paper or publish your content after you have filed a copyright, then they can be stopped from using or misusing that work. So that is the benefit of copyright filing. It gives you the power, it gives you the ownership, along with it secures the date of creation. Okay. So here is just an example to make you understand how much power a copyright has. Okay, so now here you can see two images on your screen, right? So the image towards your left hand side was clicked by a press media photographer. That means this is the time when Obama sir wanted to be the president of USA. There were rallies and campaigns and so many meetings going on. So during that time, a press media photographer clicked a photograph. He took it to his agency and modified that entire image into a beautiful red blue combination using his skills. Okay, so many people in this sector, in the media sector, keep on modifying the photographs just for capturing everyone, right? So after this media agency modified the image, they applied for a copyright, obviously, because the artwork was theirs, right? And then they published that image into multiple online platforms and newspapers and magazines and everywhere. Now, because it was election time, the council members of Obama sir decided that they need new banners to catch, to create more attention towards their campaign. So what happened was, the agency, the advertising agency, the PR, their PR team who was responsible for all these advertising materials, see, was a bit lazy person. Okay, so what he did was, he was like, who will actually click a photograph and edit it and create a banner? Let's just Google and find something interesting. So while they were surfing through the net, they found a beautiful red blue combination image, which you can see on your right hand side, and then they used the same image with the title Hope and published multiple banners across USA. Now, this is these are we this what we are talking about is banners, right? So they just printed a Hope title, and without a permission they just printed across this image across USA. The media agency, the press media agency who actually created this image, saw the banners. Okay, they are news media people, they'll see it anything from anywhere. So they saw the banners, and one of the member from the media agency decided to have a talk about this with one of the council members. So the next day he walks into the council office and he's like, you know what, sir, I'm from the media and I want to have a quick word with you. So one of the council member decided, yeah, he was like, he was very polite. He was like, let's walk into my cabin and have a talk. See, media attention during election is of huge importance because it helps the people to know what type of politician they are voting for, right? So they started having a talk, and the press media guy, he was like, sir, we saw the new banners that you have printed across. So the politician, the council member was very, he felt wow. So they are here to appreciate it. So the guy, the advertising, sorry, the guy from the media, he was like, "Sir, I have a request. I want you to remove all the banners with that face right now." The council member was a bit confused, and he's like, "What? Did I hear wrong or something? Are you drunk in the morning? Like, do you know what you're asking for?" The media guy was very calm. He was like, "So the image that you have used into your banners is created by my agency. We actually have the copyrights for it. And you decided to use the same image without giving us any form of credibility or taking any of our permissions, and that is quite against the law. So either remove all the banners, or I am media, I'll just go outside and let other people know that the person who wants to be the president of USA is not at all ready to give us our copyrights. What if tomorrow he becomes the president and take away all our constitutional rights and just get us home arrested?" See, this was not a big agenda. But in case if such a matter comes into limelight, then the opposition party is definitely going to benefit out of it, right? So the council member was a bit smart. So he was like, look, we cannot remove the banners. It is kind of our prestige issue, as you can see. But I know you are media and you cannot keep your mouth shut. But for this case, I'll want you to keep your mouth shut. So tell me how much it will take. These media guys were paid in huge amount, and the news was not out till the elections were over. And once the elections were over, nobody cared about what news people are talking about Obama sir, because he was an expected politician that time. So that is the power of copyright. Even in India, if you are a victim of copyright violation, like some of your work is copied and somebody cannot pay you for whatever violation money you're claiming for, then that person can be put into a jail for a term of 7 years as per the constitution. So now you should know what the value of copyright is. Okay, you are have been writing so many papers, so many research articles, and everything you have been publishing it free of cost online, right? Or maybe giving it away to publication houses. Now those things are wrong. Understand why? See, whenever you decide to publish a paper with any of the publication house, they sent you a terms and conditions page which you have to sign and revert it back. Have you ever read it very carefully? See, it's a human mentality. If I have to install a software, there is a terms and conditions tab and I'll just click I agree, because everyone does that. I am no genius to read it, right? So that is the mentality we all carry. Do you know what are the terms stated in that TNC page shared by a publication journal? They actually claim that the content that you're going to submit here to the publication agency is from now on the ownership of the publication house. We have the right to translate, modify, and republish it the way we feel feasible. You, as the author, cannot stop us in any way possible. So now what happened? Understand in layman language. Suppose you have a house, you're not currently using it, or you think, you just want to show it off, rent it out. So instead of signing a rent agreement, you decided to sign an entire transfer deed. Okay, you just gave away your house for free. Will you ever do that? See, we will never do a mistake like this when it's a matter of a physical property. But because here it was a matter of a mere paper, nobody cared about it. And we just signed it off to somebody, who decided to take value of it. I have seen where people pay the publication house to get their paper published, and then the publication house charges the author to just even download or see their papers. Can you see the brutality? Actually, you have to file a copyright before you submit the content. It will give you the ownership on the content. And then when the publication house decides to file for a copyright, again, they will file it as a publisher, not an owner. They have the right only to publish your written content and not to own your content. So that is the mistake which we have been doing for ages. Let's stop it. Okay. So here is one more example of a case of infringement which happened with one of our Indian company, that is TCS Services. Now, as you know, TCS provides third-party services to companies outside India. So Epic System is a software manufacturing company in USA, and they hired TCS to do all the maintenance work and database management in their client data. So they installed multiple softwares in hospital chains, and TCS was taking care of the maintenance work. See, whenever a third party company is hired to work in your project or in your software or something like that, you actually sign an agreement. There is always a confidentiality agreement which is signed, and which has few clauses which states that we will be sharing our client's data, our confidential algorithm, our databases with you. In case if there is any form of breach of data or copying of the data, you will be held liable with injunctive relief. Now, injunctive can be anything that these people demand. Now, what happened was, this agreement is usually signed by the managers of the company, okay, the business managers. But the people who come to work in the company are usually the software developers or the technical heads and all those people who are not aware of such agreements. Believe me, I have been in the R&D sector for a bit, and I know the culture that Indian companies follow. None of the employees know about confidentiality agreement. People discuss about their projects, secret confidential project, in public. They do not understand the confidentiality and copyright sectors or patent sectors, which has been a big drawback in our Indian company. So that is what happened. The employee from this company TCS loved the software, loved the algorithm. So when he came back to India, he suggested a similar software to be implemented here in India using a similar algorithm, and the software was launched under the name MedMantra. Epic Systems came to know about it. They slapped TCS with a compensation amount of $940 million. So now you can understand the importance of copyright. See, the violation can be done by any employee. Okay, if you are new to a company, think before you copy a data from online. When you are a student, when you are a faculty, if you're using any data just to study or to teach someone, it is okay. As per the government law, there is no restriction. But as soon as you decide to, you're working for a company or you start your own company and you decide to copy paste content, it can create huge violations, and that can be of a bigger problem. So you need to think before you act. Okay, so here we have arranged few question and answers which we usually get from the public. So addressing this will make you understand the concept a bit more better. Okay, so the first question is, what does copyright actually protect? So understand, copyright does not protect an idea, it protects the expression of the work. That means suppose you decide to write a paper on any of the technical data that your research you're working on. So the idea on which you're working is not protected, but the content in the method or the way you decide to describe the idea, the words you have used, the technicality you have used, making the content simpler, it is what is protected under copyright. Okay, so the expression of the work is protected and not the idea. Okay. How long I have to wait to get my work registered by the Copyright Office? So basically, as per the website, the government official website, they say 30 days. But believe me, they have lot of workload that comes because there is only one office in India, that is in Delhi. So they have a lot of workload. So at times it takes at around 45 to 60 days also. Okay. So like, do not think yare mera kyun nahi hua. At times, yeah, there is just one office with 130 billion, like 130 crore public. So you need to understand that there can be a lag. Okay. What is the term of copyright? Now, this is a very interesting question. So, a term of the copyright is till the author is alive and 60 years after the death of the author. Okay. So, what happens? The example is of Michael Jackson. We all know him as a legend, right? So, all his work had rights protected till he was alive, and his family, even after his death, earns the royalty for all the work he has done, and it is still in public. So till 60 years after his death, his family will receive the royalty for all the work he has created and filed for a copyright. Okay. And the one of the most crucial part is copyright is valid internationally even if you file it only in India. That means if you have filed for a copyright here in India, and if that gets copied outside India, maybe in US or Germany or China or somewhere, you can actually file a case to stop those people from using it. That is the benefit of copyright filing. Okay. So I hope copyright is quite clear. It protects all the artistic work, all the author writing based work, our paintings and softwares and videos and movies and everything that you see and there is art into it is protected under copyright. Okay. So the next topic that we'll be discussing is trademark filing. Now, a trademark helps to protect a brand's identity. That means, suppose you decide to buy some product in the market of a reputed brand, of a reputed company, or you wanted to visit a place that people have been talking about. How do you know that the brand is original, or this is the actual brand you want to buy from, or this is the actual institute you wanted to visit? So basically, you recognize a product or you recognize an institute using its brand, using its name, logo, symbols, taglines, jingles. These things actually provide identity to a brand, right? For example, suppose I'm driving from Rajasthan to Maharashtra, and I'm hungry. So, being a frequent driver, I know that I will not prefer eating at any local dhaba because there is a possible chance of getting a food poisoning. So, I'll prefer to eat at a food chain. So, when I'm driving, I suddenly see a capital yellow M. I'll immediately recognize that it is McDonald's because that capital yellow M is the proprietary symbol of the company McDonald's, and nobody else can use the same symbol for any food chain here established in India or outside. It's an international brand. So that symbol provides the identity to a company that is protected under trademark. Okay. Few more interesting things are trademark like sound, smell, dialogue, voice, three-dimensional design. Now these things are also applied for trademark. Now understand why. Suppose I decide to go and buy a perfume. Will I just check what brand it is? No. If I'm investing $1,000 into a perfume, I need to know that it smells good on me, right? So I'll have a smell check. So every perfume manufacturing company, whenever they decide to launch a product into the market, they will file for a trademark such that the smell is not copied or reused by any of their competitors. Okay. Talking about sound, voice, these are identity of a person or maybe an industry. Like for example, when we were kids, or even today, uh, before the Tom and Jerry, the cartoon Tom and Jerry starts, there is this sound of a lion roaring, right? There is just a head of a lion and it roars, and that sound is so nostalgic. We even if today, like even today, when we hear that sound, we'll immediately link ourselves to the when we were kids, right? So that sound is also trademark, and nobody except them can actually use it. Every movie or every other person who uses the sound is paying a huge royalty to these people for using that sound. Okay, that sound is trademark applied. Okay, these are few of our Indian trademarks like Amitabh Bachchanji's voice, Sunny Deol's voice, few of our celebrities like Sachin Tendulkar, SRK, that is Shah Rukh Khan, has his initials SRK trademark. Namo, Narendra Modi, has his initials Namo trademarked. Um, Now, just think, can I apply my name, Pooja Menon, for trademark? No. What is the difference between me and them? I know many of you want to unmute yourself and say, you know what, they are famous, you're not. Correct. Today, till in this present day, I'm not famous. But these people are a brand in themselves. Now, suppose Sachin comes to your place and he's like, you know what, this is a fantastic water purifier and you should buy this. You know, I have been drinking from this from age, and you know, I never age because the water is so pure. He doesn't have to even market. Just by, you know, if Sachin comes on screen and he's like, you know, buy this water purifier, I have people around me who will rush to buy that. Okay. And people will actually trust that, you know, he became a great cricketer because of the water from the purifier. Now, suppose if I come to your place and I'm like, you know, sir, this water purifier is great, buy it. You will actually slam the door on my face because I look like a saleswoman to you, right? So that is the difference. These people are already a celebrity and they have their brand value. But as an individual, what can I apply for a trademark? Now, suppose I decide to start my own company, or I decide to start my own channel, YouTube channel, or I decide to start a website, I decide to create a software or write a book or create a product, and I want to name it. Then that name I can apply for a trademark. The name of a book, name of a project, name of a website, these all things can be applied for a trademark. But I cannot apply my own name to be protected in a field because I am not still famous or a brand value. Okay. Now, when you decide to apply for a name, you need to take care that you do not violate any of the existing brand. Like you cannot start a McDuck, which actually looks like McDonald's. That's a huge violation. You cannot actually start a brand called Hikey because it resembles Nike. All these things will create a huge violation. Maybe it will help you to start your business, but as soon as you come into the picture legally, all these things will get you into bigger trouble. Okay. So that was all about trademark. Okay. So I hope copyright and trademark is quite clear to you. Then now we'll be talking about a very interesting topic, that is patent filing. Now I know many of you here might have heard this word. This has been a very frequent word in nowadays. Our current, prime minister has been helping to promote IPR activities at a huge scale by decreasing the government fees of institutes, providing a lot of fundings to the institutes who promote IPR activities, and so on. So what is patent? Now, as I told you, in case of copyright filing, anything creative, anything artistic, anything without a logic can be applied for a copyright, right? Like if I decide to paint sun pink, nobody's going to come and stop me. No, they're not going to do that, right? So if I want to file for a copyright for a pink sun, nobody's going to stop me. But talking about patent, it helps to protect ideas, innovations, theories, designs, working mechanism. In that case, government will ask two questions: why you're doing it and how you're going to do it. Okay, so if you do not have a reply to how you're going to do it, at least theoretically, see, there is a big myth that to file for a patent you need to have a physical product or a prototype. No, you don't need. You only need theoretical documentation. So suppose you have an idea and you can at least theoretically explain how it is going to work, then you can apply for a patenting. Okay. Now, basically, patent is bifurcated into three categories. One is called utility process patent. Second is called design patent. And third is called genomically engineered plant and animal patent. That means the third category basically works with cells and organisms and mutations and microorganisms and all that sector. So we'll avoid it for right now because does not matter in our sector. So we'll focus on utility process patent and design patent. Now let's understand the difference. So here I have a mug. Now, what do I use a mug for? Basically, if I want to drink a hot or a cool beverage, basically I'll use a mug. Now, there are so many companies that manufactures mug, right? So the only thing that they decide to change is the shape of a cup, right? So whenever there is a change in the design structure, I'll apply for a design patent. But there were some geniuses who thought that, for an adult to hold and balance a single-handed cup is easy. But suppose there is a kid or a toddler who is like 3 or 4 years old. If I fill a milk till the top of the mug, it is very difficult for the child to balance from his using his tender, hands. So what that genius person did is he attached one more handle to the cup. So now that kid can hold it from both the end and can sip the water or milk or whatever is in the glass. So when I changed the design to enhance the utilization without changing the working of the cup or any other thing, then I'll apply it for a design patent. Now, talking about a process, utility patent. I like to have my coffee, morning coffee, hot and frothed. Okay. So the problem is, I am a normal person and I don't have a frothing machine at home. So what will I do as a basic person? I'll take a bit of coffee, sugar, a drop of water, and I'll start beating the coffee because I know we all know that when you beat the coffee well with the sugar, it starts getting frothy, and just add hot milk and you can have a good frothed hot Dalgona coffee, right? But imagine waking up at 5:30 in the morning and making a coffee. The beating takes around 10 minutes. It's painful. But I'm an engineer. So what I did was I decided to have a small motor with a stick attached and a switch. So when I just switch on the motor, it will start rotating that stick which is attached to its rear end and start beating the coffee. Okay, yeah, I'll have to put in the concentration of coffee and sugar that I prefer, but the beating part is automatically done. I can enjoy my 5 minutes looking outside the window, right? Once that beating is done, I'll just switch it off. I'll just, unplug that stick, pour good hot milk, and I can enjoy my morning coffee. So, my laziness gave me an idea to create a frothing mug. So, I enhanced the property of a normal mug by adding few components, few characteristics into the cup. And here I can have a frothed coffee. So, when I enhance a characteristics, a working, by adding few components or change the working mechanism, I'll apply for a utility patent. So now you know the difference between a utility patent and a design patent. Now, see, now you also need to understand that every country have their own terms and condition when it comes to the matter of patent filing. Like when you decide to file for a patent here in India, there are few things that the government restricts that cannot be applied for a patent. Like for example, here in India, the discoveries cannot be patented. Now, understand the differentiation between discovery and invention. Now, if you find something, like you're looking for something and you just find it, it is called a discovery because you did not create it, you just found it. But on the other hand, if you decide to create something from a scratch, that is where you gave birth to an idea, that is called an invention. So here in India, discoveries cannot be patented. So as per the first rule, discovery of a scientific principle of or the formulation of an abstract theory cannot be patented. Like for example, Newton discovered gravity. We all know that, right? The apple story. So once the gravitational force was discovered, he can give it his own name to the theorem and theories and what all were created, like Newton's law of gravity. But Newton cannot come up and say that, you know what, I found gravity. So let's do one thing. You all have to stop using gravity. You all have to float now. Is it possible? Even if it was possible, he cannot do that because it's a discovery and not an invention. So anything scientific that has been discovered, he can give it his own name. You can even give it your own name if you find something, but it cannot be applied for a patent. Okay. The second is discovery of living thing or non-living thing. Suppose you find a stone or a plant or a fish or any animal, then it is still a discovery because it already existed on the earth or maybe outside. I'm like, if you discover an alien, it's still outside the earth and it's still a discovery. You can give him your own name, but still you cannot apply for a patent. Okay. An invention which claims anything obviously contrary to well established natural laws. That means some of the invention actually works, some of the invention which you propose does not go hand in hand with the natural laws. See, there are certain things which have been defined. Like without an input energy, there cannot be an output energy. Okay. Energy converts from one form to another, right? The law of motion, all these things are very well defined, proven by great scientists. Now you come up with a theory like, I have a machine, without giving in any power, it will give you so much output power. The person listening to you might be very confused and might start laughing because it actually contradicts to natural laws. It cannot be applied for a patent. Okay. So an invention which causes serious prejudice to human, animal, and plant life. If an invention creates any form of harm to humans, animals, or plant, that cannot be patented. But on the contrary, if you develop a chemical formulation that can kill something that is harming these things, like for example, pesticides. And so pesticides basically kills the pest, but it protects the plants and help the humans. So on that end, the chemical formulation of the pesticides can be applied for a patent. Okay. I know hypocrisy, but this will work for you. Okay. The mere discovery of a known form of a known substance, new form of a known substance, which does not result in enhancement of the known efficiency. That means, let's talk about carbon. Okay, so we know that coal, graphite, and diamond. These are isotopes of carbon, right? So it's just taking different forms in the core of the earth. It is still a discovery. Even if it's diamond, even if it's graphite, even if it's coal, you did not invent these things. It already existed on Earth. You just found them. It is called an discovery. But there is a beautiful field called nanotechnology, which works with carbon. Everything created in the sector of nanotechnology is an invention. So now you can clearly understand the difference between an invention and a discovery. Okay, the mere arrangement or rearrangement or duplication of a known device. So if there is a device that already existed, you just combine two or three devices just to make it, just rearrange the position to make a better functioning, then you cannot apply for a patent. Okay, it has to provide some form of enhancement, work collaboratively, work as a unit, then you can apply for a patent. Okay, India is an agricultural based country. So here, if you find a method of making agriculture simple, that means a method of sowing or reaping or something like that, India government will restrict that patent. But on the other hand, if you design a machine that can make this agriculture simple, like for example, sprinklers or tractors or something like that, you can apply for a patent, because then it is not a method, it's a machinery which is making the process easier, so you can apply for a patent. Okay, similarly, in the sector of medicine, if you have a method of treating or diagnosing something, like for example, when COVID was in picture, so there was a method of treating or identifying that a person is COVID contaminated. In that case, that method cannot be applied for a patent. But if you design a medicine, or if you design a medical equipment which can make the diagnostics easier, then you can apply for a patent. Okay, but in case of pandemic, every patent was made open, which can, which in India at least, which can help in human benefit. Okay, in India, a mathematical formulation, business method, or a computer program or algorithm cannot be patented. So if you have developed a pure software, okay, which works as a mobile application, or if it's a business idea, then you cannot apply for a patent. Okay, an invention which is in effect is a traditional knowledge. If something that you have created came from a traditional knowledge, a very basic knowledge which was known to people today, or maybe 10 years or 50 years back, it is still a traditional knowledge and you cannot apply for a patent. Like for example, a medication using tulsi, a medication using amla or something like that, it already existed, you cannot apply for the formulation until and unless it has a modification using chemicals. Okay, now this is one of my favorite facts, which states that 90% of the improvements that happens, sorry, 90% of the inventions which are being filed worldwide is filed on improvements. That means the product already existed, somebody just looked at it and they were like, you know what, I don't think this is fun, let's change the design or let's enhance the feature. 1% modification to any of the existing product is what is being filed worldwide. So only 10% patents are filed on something out of the blue, out of the new, right? But 90% applications are being filed on something that already existed, and people found a way to modify it, enhance it, and then apply for a patent. Okay, see, if you are a fan of the the cartoon, the Black Panther. Okay, so in that movie, the girl, the sister of the Black Panther, is a actually an innovator. So there is a scene where the girl states that uh, it does not mean that if something is working, it cannot be modified or made better. If something works fine, it's good, but there is always 1% scope that can make that product better, and that is all about invention. So that is what you have to do. Look at a product, make 1% modification into it, 1%, and you can apply for a patent. That is how easy the patent filing is. Okay, this is one of the very good examples. There is existed a time where gramophones were used to play music. Then there came a time of cassette players, CD players, Walkman. iPod, and now your phone is more than enough, right? But somebody thought that if I want to listen to music walking on the street, carrying a gramophone or a tape recorder is not going to work. Somebody came up with the idea of Walkman, and that is how invention takes place. It is, where there is a necessity, there is an invention. Like the people in the 90s, we all had landline phones. You know how painful it is? You're a kid, you want to gossip with your best friend, your parents are right besides you, you cannot talk about what happened in your classroom because the wire is attached, it's a landline phone. It was painful. Then there came a generation where we had cordless phones. So at least you can take the phone and just walk around the house or go to the terrace and talk to your best friend. But still, you cannot leave the premises. Okay. Then came the time of mobile phones, the small ones which had keypad. It was very efficient. Believe me, you can sit in the classroom, text with your one hand, and nobody will come about it. Okay, you don't even have to look. You get to be very expert. And the only game that was fun was snakes. Okay. And now is a generation, an era of smartphones. There may be 50 students or 100 students in the seminar, and everyone will have a different set of mobiles with different enhanced cameras and processors and memories and everything. 1% more modification, whether it's the shape, the design, the cameras, that 1% design is filed for a patent. Everything that you touch in today's world is applied for a patent. Okay. See, when we say about patent, every small thing to the big things are applied for a patent. The best example is the toothbrush that you use. How much importance does it hold? 2 times a day, maybe, and 2 minutes a day? But the company which manufactures the toothbrush has so many varieties, so many designs, and every design that is endorsed to you is applied for a patent. Do you know the company Gillette? Now if you have a if you are a male, obviously, but if you have a, brother or father at home, because they will be using Gillette products, that is razors. That company has 72% asset value, only IPR. That means if that company sells its IPR, 72% of the asset value is just IPR. Its patents, its trademarks, its designs, everything that it holds. 72%. So imagine how much valuation that company holds only on the IPR. Now you know the importance of IPR. Okay. It does not matter how small the thing is. Razors, how much can we think about it? But that company has invested thought, and it's one of the leading companies in manufacturing razors. Okay. Now, this is just example of patents that we decided. See, I told you, if you want to create something innovative, find a problem. सो डोंट थिंक कि यार मुझे कुछ इन्वेंट करना है, फाइंड समथिंग की प्रॉब्लम क्या है. सो एप्पल, as we know, it's a beautiful innovative company. Okay, so Apple, the team of there was a team in Apple who started talking, and they were like, you know what, we are going to have a generation of flip and foldable phones. What can we do to be in the race? Now the patents of foldable phones and mobile screens are with different company, including LG. So Apple was curious to be in the race. So one of the members from Apple gave a suggestion that let's make bendable mobile covers. Now, this is quite interesting. See, uh, this is a plastic cover for a normal mobile phone. Okay, so if I use a bendable phone, I cannot use this cover because it will not bend. Okay, it will break. So it is not efficient. Now, just a second. Now here I have a rubber mobile cover. You'll be like, plastic you use karo, rubber use karo. Now I'll try to bend it. Can you see how clumsy this looks? If I decide to bend a mobile cover that is made of rubber, it will bulge from the side. Imagine you have a mobile phone which is worth say 75,000 to 1 lakh minimum. Okay, and you have a bad mobile cover. सारे impression पानी में फिर गया, right? You'll never do that. The number of phones we change in a year is less, 100% less than the number of mobile covers we'll change. So Apple came up with a material that is so flexible that it can be attached to all the end of the mobile phones, and it will bend and flex as per the mobile's condition. Okay, so that material which was created was applied for a utility patent because it's a product, it's a process, it's a chemical formulation, a material. But the design that they adapted for the mobiles were applied for a design patent because it's just a structural change. The material has composition and all such things. So it was applied for a utility patent, and the structure was applied for a design patent. So think how much deep every company is involved thinks about. See, when I talk about design patent, people think, say, oh, ये तो बहुत simple चीज़ है यार. Just take design change कर दो और apply कर दो. But design patent has huge impact on what you observe in the society. Like, uh, do you know an industrial revolution took place when needles changed just the position of the eye? Now, if you have seen your mother or grandmother stitching, the needle that they use has an eye at the top end. So the thread is, just put into the eye and you can just start stitching. But the needle that is used into the machine, in the stitching machine, has the eye at the bottom end. So when the position of the eye of the needle was changed, an industrial revolution took place. Apart from that, the needle that is used for different type of clothing, like say cotton, denim, leather, different type of material, the shape of the needle changed. Obviously it has to be done. So when the shape of the needle was changed as per the clothing, multiple design patents came into picture. Okay, so this is one of the very good examples. A normal Apple phone, if you touch it, it has more than 200 patents. So Apple is not just a company because Apple is not just expensive because it's a brand. Apple is a company which puts in a lot of hard work to innovate. Imagine a normal mobile phone with more than 200 patents into it. They are a company that believes in invention, innovating, modifying. Everything that you touch in an Apple phone has been applied for a patent. Okay, we have arranged few Q&A here which will actually give you much better perspective to understand what patenting is. So, can any invention be patented after publication or display in the public exhibition? So please understand, if you publish any of your work before applying for a patent, the novelty, the uniqueness of the idea gets lost. So if you decide to publish a work before filing a patent, the government will not consider the valuation of it. So do not do that. We have lost so many research because which were innovative, because they published papers, because we were in so much hurry. Paper had so much importance in the last few years that everyone decided to publish papers than filing for a patent. So you have to do is, you file for a patent and then immediately publish your papers, no problem. But the date of patent filing has to be before the date of publication. Okay, in which language can a patent application be filed with Indian Patent Office? So here in India we permit two languages. One is English, which is generic, and second is Hindi. If a person is unable to write it in English language, even the government will accept sorry, the government will accept Hindi language. Is there any jurisdiction for filing patent application in India? So please understand, there are 4 patent offices here in India. One is in Mumbai, Chennai, uh, Kolkata, and Delhi. So the jurisdiction depends on the state that you belong. So suppose you're from the state of Maharashtra, you will definitely file it in Mumbai. If you're from Gujarat, the jurisdiction is still in Mumbai. If you're from, say, Madhya Pradesh, your jurisdiction is still Mumbai. If you're from, say, Uttar Pradesh, your jurisdiction shifts to Delhi office. If you're from, say, Sikkim, the jurisdiction shifts to Kolkata office. If you're from, say, Karnataka, the jurisdiction shifts to Chennai office. Okay, so based on your state, the first applicant, the jurisdiction will depend. Okay, what is the term of patent? So if you're filing for a utility patent, the term is for 20 years. If you're filing for a design patent, the term is for 15 years. If you're filing for a medical patent, like which is related to say medicines, formulations, pharmaceuticals, the term might vary depending upon urgency. Like here in case of COVID, all the medications were made public, so multiple medicines can be made available into the market. Does Indian patent give protection worldwide? So please understand, there is no such patent that can give you protection worldwide. It's a myth. It's a wrong information that has been fed into the market. So when you talk about international filing, you will have to file a patent in India first because you are an Indian citizen. There is an entire section in the patent law which states that if you're an Indian citizen, file a patent in India first. Okay, so you have to do that, and then you'll have to apply for a PCT, that is Patent Cooperation Treaty. Apply it outside, and then you have to select the country that you want to apply the patent for. Okay, so when you decide to file for an international patent, ऐसा कोई भी facility नहीं है where you apply and all the country will have the rights. No, that is not possible. You will have to file a patent and in India, then you will have to select the country in which you want to protect by paying the fees of that country, and then you can apply for an international application. Does the patent office keep information of the invention secret? So when we talk about secrecy, there is something called trade secret, which is not valid or existing in India. So what here happens is that in India, your patent is kept confidential for a term of 18 months. That is the publication period. After 18 months, the idea will be mandatorily published. If you want to publish early, there is a facility called early publication, and you can have your data online within 35 to 40 days. Okay. Can one subscribe a copy of patent office? It does not have to be done. It's an online copy. Okay. Okay. Talking about patent valuation. See, I already told you that to file for a patent, you do not need a product. So there is a company called Vernetex. There are so many companies outside India. Their only business is to sit and make multiple ideas in the advanced fields. And once the ideas are ready, what they do is they sell or license that ideas to multi-billionaire companies like Apple and Facebook and Google and Amazon and earn licensing money from them. So what they did is they are a group of 15 people. They develop brilliant ideas in the upcoming technology like IoT, VR, artificial intelligence, machine learning, file for a patent. And then the company who actually want to manufacture the product, because the patent is already active, cannot manufacture the product. So they buy the idea or license the idea and then use that into their implementation. So now you know the value of patent. Apply for a patent, wait for somebody to use it or violate it. And then you can just go and stand in front of them and demand the money that you deserve. That is the power of patent filing. So India in the year 2019 was ranking 7th with almost 50,000 patents. Okay. In this year, the count has reached to 88,000. It's impressive. But let's talk numbers. See, 7th rank internationally is a good number. But China files more than 15 lakh patent a year. You should see their patent. See, we think of China as a place where everything gets copy pasted, but you should actually check their databases. They have left no field untouched. They do so much research into everything possible, and they file more than 15 lakh patent a year. US comes around 5 to 6 lakh a year, and India, even with a population of 130 crore, we still cannot file 1 lakh patent a year. And do you know what's the saddest part is that if you check US patent database, the inventors are mostly Indians. So what we do is we take our initial education from India, obviously being born in India, then we take our entire brilliance outside India and file patent for other country. That we have been doing for ages. Okay, we rank second in immigrant patents. That means Indian going outside India and filing for patent. We are ranking second. That's the brilliance of our brilliant people. So let's improve that. We as a company has tried and last 2 years, almost 3% of Indian been filed by our company. That is how much put institutes, individual startups, entrepreneurs, patents. And we can do much more with institutes with so much going on, improve and because we have a system with so many and faculties, we can improve them. And see, when I told you that there are only 50,000 to 80,000 patents being filed in a year, think about competition. There is no competition. When I talk to students and talk about placement, they are like, jobs available nahi hai, bahut competition hai market mein. Actually, there is no competition. In that 80,000 patent, almost 60,000 patents are filed by companies outside India. Like suppose if Samsung comes and file a patent in India, or say Google comes and files a patent in India, it will show in our account. that is not an Indian patent. They actually file patent here to restrict us from using their technology. So in that 40%, others are Indian companies and pharmaceutical sectors. So we are hardly in 4 to 5%. 4 to 5% of 130 crore population. So when you have a patent in your portfolio, in your resume, think the impact that you will put into the market. If you sit in an interview and say that, you know what, I have an innovative mindset, I can think out of the box, I can create something which nobody thought of, people will think you're bragging. But show your resume with a patent application number, show with a copyright application number, and people will understand that yes, a person who knows about IPR, who has filed an IPR, is definitely an out of box thinker, and that is the true potential that a company wants, or the next educational institute wants. Okay, there are so many benefits to the institute with respect to accreditations, improvements in educational culture, all these things with super grand facilities for IPR file. That all can be done if you have an IPR culture and IPR cell with promotion of IPR activities. Okay. So we basically Vibrant play a role here. So we help the institute. We actually go through the project. See, whenever a project is taken place, usually people have a mentality to do a good research or to create a good product. What we as a team do is we look into the concept and we find 1% patentable concept which is hiding in your idea, which is hiding in your project. Or with respect to that, we help in enhancing the idea to a patentable concept. That is also possible. See, as I told you, 1% is the modification that you require. We have a group of more than 37 experts who can actually help you to think outside the box and find that 1% modification which can make your concept patentable. And that is the role of our company. We are not just an IPR filing company, we are actually a virtual R&D company which helps to enhance the ideas, enhance your project to make it patentable. Okay. So here are a few examples of the ideas which we have helped the students and the faculties to file. And with respect to the same, we have helped few people in enhancing their PhD projects, their research work. So there was a medical person, and he was like, I need a machine to heat intravenous fluid. Now, what is intravenous fluid? Is basically the fluid that is injected to a human being. Maybe it's blood or glucose or IVF or something like that. Now, basically, that is quite chilled. It is preserved in quite low temperature. So before it is fed to the human body, it is actually raised to a good normal temperature and then fed. Otherwise, the human will die of heart attack. Okay, but there are few places across the world or in India where there is no electricity, but medical facility is a must. So he wanted to create a chamber which can actually heat the intravenous fluid without using electricity. We have a beautiful team working in nanotechnology. So they found a material which can get agitated with light and actually release heat, a controlled amount of heat. So we created a chamber which was, layered with nanomaterial. It has few light assemblies, and it was solar powered. So the solar energy which is received onto the chamber is stored, and that stored energy was used to glow the bulbs inside the chamber, which actually controlled the agitation of nanomaterials, and the nanomaterials generated controlled heat which was used for the heating of the IV fluid. And that was possible because we collaborated with somebody who had an idea. The idea is yours. We just help to enhance it and bring out the actual concept which can be put into the market. Okay. So here we had a medical, similarly in the medical sector, where they wanted to have a portable device to identify if your blood has bad blood cells. Okay. See, sickle cells are bad mutation that happens in your blood RBCs. So we took that concept, we took few of the technologies, made a portable device that can be just attached to your skin. It can continuously detect the blood, just use the needles which are micro level, which does not even feel to your skin, and it will just suck the blood, use that, do the analysis, and give you the report on the same time. So that was created by our team. Here we made an agricultural shoe where a student came up with the idea that to sow the seed at equal distance is a bit hard. You have to dig and just do it, and it might hurt your backbone. So we came up with a shoe, a farmer shoe, which had a facility to dig, and a button. When pressed, it will just drop the seeds and close. So only few seeds are released and then it will close. So that was decided. So a person can just walk at equal distance and do that method and use that shoe implementation. So that is all about IPR. I think you might have understood what patent, copyright, and trademark filing is, how these and how it can help you in. Okay, so if you have any question, we can address the same. Thank you.
Students, now it is interactive session open. You can raise your questions. But can I have some questions, madam?
Yeah, sure, ma'am.
Yeah,
Please,
students
please.
can prepare their questions. Students, you can put the questions in the chat box also, which will be read and answered. Please put your queries in the chat box. Madam, you said something on publishing the papers. Yes, they have certain formats to be completed by the authors, and it's huge. So without reading, we sign it. So what is any alternative? I mean, we should go for copyright first and then apply for the publications. What is your suggestion?
Okay. We'll always suggest that, ma'am. The problem is right now when you're signing and submitting the data, when the publication house will file for a copyright just to avoid the data to be copied from their website. So when they
Yes.
apply it, they'll apply it as a owner because the copyright has never been applied before. So instead of filing as a publisher, they apply it as a owner. So now they have the ownership of your entire work. Instead of that, you need to file for a copyright as the owner of the work, give them the rights. Whenever you sign it, they cannot reapply it as an owner, they'll apply it as a publisher because that is the only facility the registry has provided. If I decide to refile an application, I need to have a written permission from you. So when you are providing them the rights, you will only provide publication rights, not the ownership of the work. So that needs to be taken care. So file a copyright first, so at least you will have the ownership of the works, ma'am.
Okay. But then we need to take it as a practice for every publication because our PG students are also publishing the papers along with us. I mean, a guide is necessary in publication. So we need.
Ma'am, see,
Yeah.
the papers which you think has a lot of potentials, apply for a copyright. If you
Yeah.
think this paper does not have a higher value, then
Yeah.
you can let it go. That is it.
Okay, that is there.
Ma'am, the government fees is also very less. It's just 500 rupees. The publication house charges much more than the copyright. So you can actually apply it for every paper also.
Oh, but then the government procedure is difficult.
No, ma'am, it's very simple. Actually, like if you decide to have a workshop, I'll actually teach you on hand, ma'am. It takes around 10 minutes to file, and the government takes around 45 days to give you the certificate. It's that fast.
Okay. So whenever we'll get a chance, we'll have a workshop as well so that you can guide us on how to. At least all the faculty members will be definitely interested in doing this because we are, blindly doing all this. At least we can request the publishers not to go for ownership copyright. They can go
Yes,
publishing
absolutely.
copyright. Yes. So
Yeah, but at least keep you as a co-applicant. They are not even keeping you as a co-applicant. Like you would have no ownership on your entire work.
Yeah, I got the point. Okay. So we'll have to practice. At least we can appeal them not to go for a owner copyright. Yes.
Correct.
You were saying something, sir?
Yeah,
Yeah.
actually, Sushil Deshmukh had some questions. He's put up in.
Sushil.
So, how much fees for filing the patent? So, actually, the government fees for the utility patents are for the registration. It is around 1,700 if you're filing offline, and for the examination, it is around 4,000 rupees. That much fees. Total around, if you calculate it, 5,600 is the total fees, or 5,700 is the total fees for the utility filings. If you are filing with the if you are filing the design patent, if you are filing it as an individual, it is just like a 1,000 rupees government fees. And for the institute also, they have for the institute, the 4,000 fees is the charge.
Any more questions from students?
Ma'am, I had a question.
Yes, please.
Ma'am, as you said that while filing a research paper or publishing it, we should take the copyright. But when we sign the paper which is given by them, the copyright claim, they said that you won't have any rights on the paper hereafter when you publish it.
That is the
So
problem,
is
ma'am.
copy
Actually, we have never tried to even question them. That is the biggest problem, ma'am. The problem is we are desperate to file a get the paper published. We need to
Yes.
understand that the journals cannot even work without us publishing the work, right? So we need to actually let them know that we want the ownership on the work you have done. I know how much. See, I have been drafting patents for like 8 to 9 years, so I know the pain that it takes. And I even know to write a paper it takes months, because the research that you have to do and the content, the plagiarism and everything goes on. And then you just give the work away for free. It's not worth the pain then. So you actually need to question them and let them know that I'll give you the rights to publish it, no problem. I can restrict the publication to you, but at least the ownership has to be mine. I cannot give it away. So if we all start raising questions, then I think the publication house will start reacting to it.
so ma'am, is this done before? Like we can do it, or because as I was publishing one of the papers, there was a like the paper mentioned that you don't have any ownership rights, and most of the journals which publish it, like IRGET or IEEE, they all have the same signing conditions.
But ma'am, if you don't even see, actually, if you have applied for a copyright and if you give the signing rights, they cannot reapply your work. So at least they will have to ask you for the permission. So that is what we have to change the culture. That is what we are saying. At least apply for a copyright. Even if they reapply it, you can actually give them the publication rights to them. Yeah, okay, fine enough. But if you decide to write a book after a few months, you cannot actually use the content of your paper into your work. So that is the biggest problem, because nobody raised the voice for so many decades, so nobody cares about it. That is the problem, ma'am. Till date, people the copyright fees, like as I told you, it's just 500. I have seen people being charged 30,000, 50,000 in the market for per page. They have been, people are paying for per page. So there was so many misunderstanding in the market. Now the things are changing. So even in this sector, all the researchers have been what do you call snatched off their property. So that is where we want you to file a copyright, and then let them know, let them try and apply. So the government won't permit it. They'll have to take publication rights. That is how the things will have to change.
Next question from students. Someone has typed.
Yeah, okay. Chitra madam has written that my copyright status shows approval. So approval means they have actually sanctioned your copyright, and it will just change into registration registered in few weeks. So this is the stage where government has confirmed, and as soon as it changes it into registered, they'll have to issue a signed certificate to you. So this is the stage between the certificate and the approval. So you will have to wait a few weeks to get the registered certificate.
Next question, please.
Is my voice audible or am I breaking?
Madam, your voice is breaking.
Actually, I'm in full network.
I think we can switch off the video so that the bandwidth will be utilized properly.
Sure.
Because video takes more bandwidth. So whatever is available, let it be for conversation, I guess. So I appeal so. If students have, students appeal to yes. There is some questions are here.
Okay. So there is a question which states that, ma'am, I think as softwares and computer programs are not patentable in India, is this one of the reasons for low patent filing in India? Yes, I agree that agree to it that here, because we are more inclined towards the IT sector, there are the number of patents which we could get from the software sector was much more. it is an ongoing fight. It is still an active fight at the registry, where people have told them that to make the software patenting allowed in India. But the biggest problem is that we have a very tough competition when it comes to a software patenting. We have companies like Microsoft, Google, and Apple waiting. See, if they decide to file for a patent here in India restricting their softwares, then we as an IT sector will not progress. We'll stop there. See, if you see our history, and there was Amazon, we started Flipkart. There was Airbnb, we started with what do you call it? Zoyo, right? So all the startups which have been funded and has reached a good level are actually the copy from US or some other place. So they cannot actually make those patents here in India at the current status. But there is a small loophole. If you can attach a hardware to the algorithm, or to the making of the system, then you can apply for a even a software patent. Like for example, when we talk about IoT or machine learning, basically they are pure softwares, right? But if the machine learning or IoT has to work, there has to be some sensors and machineries and all those things that operate well, right? So that is actually possible when there is a hardware involved. So in that case, you will have to apply for a patent. So that is possible. You have to find a loophole to find a patent. So if you are looking for something, we can have a discussion too, so I can let you know more. Thank you.
Yes. Madam, you said copyright, once you file in India also, it is valid for worldwide.
Mhm.
Is it not for other IPs?
No, that is what I see. Actually, when we talk about copyright, it's a creative work. So, like if you paint something, it's just painted once, right? So it does not harm anybody if you talk about copyright. Like if I did some painting, if I stop another artist from painting the same thing, it won't hurt that painter. But when you talk about patenting, if I suppose there is an idea which has already been filed in US, say a medicinal patent, okay? If it's filed in US and if I want to start manufacturing here in India, if the patent was valid worldwide, then I will not be able to manufacture the same thing here in India. So there are so many treaties which work here, and if you want to restrict somebody for that idea, you will have to file a patent in that country. So when you file for a patent here in India, somebody else can manufacture and sell that same product outside India without your permission. So there is some difference in the rules when it comes to the matter of patenting, because patent is always done for human benefit. So you cannot stop someone from using your concept outside India. If you want to, you will have to file for a patent. But that is not the case of copyright. Copyright is all about artistic work, right? Like if you create a music here in India, so it does not matter if somebody else,
Uses the same.
Yes, exactly.
That
If
is
this
what
is
sometimes
happen,
Bollywood is doing.
most of the IP is holded by the China. If this thing is happen, we are paying China for using their technologies. So all the financials are goes to the China, and China is holding the most of the IP in the world. So this will huge loss to the world in the economic sectors also.
So, madam, when we apply for a patent, there is a search, like whether the concept is duplicate or what. So search
Yes.
is limited to nation-wise, right? I mean, it is for country-wide the search. It's not abroad.
No. Okay. See, now you need to understand, when you decide to apply for a patent, the patent search is worldwide, because a idea can be born only once. So when you do a search, you will have to check the Indian database and all the other countries' databases, especially WIPO, World Intellectual Property Organization. So when you apply for a patent, it is only valid in the region that you're applying. But when you are searching for the idea, whether it exists or not, you'll have to search the entire database of every country.
Okay.
If it already exists in any other country, you cannot apply for a patent, because idea can only be born once.
Madam, there was, the trademark. Sound is also a trademark. Can jingle be a
Yes.
trademark or a copyright? Some slogans, some
Uh,
symbols.
okay. So there are two things involved here. When the jingle is first time written, it is applied for a copyright because it's a creative work. But as soon
Okay.
as it gets linked to a product, now if I write a jingle and it gets attached to a product, okay, then it has a market value, then it will be a trademark. As soon as it comes as a brand product, like for example, there is a jingle selling soap, right? So soap
Yes.
is a product, and when that jingle gets linked with that soap, so I start recognizing the soap with the jingle, it's a trademark. So I'll apply
Okay.
the same thing for a trademark also. Yes.
Ma'am, I'm
So
interested
it will be both.
to know what we are always comparing like how many patents are filed by different countries, but how many
Mhm.
granted, that data should be compared. What I feel
How many
are really, I mean, awarded, grant.
granted? Okay.
Yes.
Ma'am, if we start doing that, I think India will fall far behind. So I think it's better for India to at least see that how much.
Oh.
Ma'am, we get when WIPO, World Intellectual Property Organization, publishes their data. There are two datas. One is the granted patents, and other is applied
Yes.
patents. But the
Applied.
thing is, yeah. So what happens is the ideas which are granted, some of the ideas take 4 years, 5 years to get granted. So so that count shows after 4 to 5 years. So but the date of but the application applied shows it, shows the report of the current year. So they show both the data. So that is why India is ranking 7th, because we have a lot of patent applications being applied, but when we start comparing to how much is granted, our ranking falls very badly.
Yeah,
So
yeah,
we,
yeah.
yeah, so yeah, I know, I understand your concept, ma'am, but still here we just to, if अभी
Because
तो
you
सिर्फ वो
know,
कल्चर शुरू हुआ है इंडिया में, अगर हम अभी से ही उनको
लेकिन
डिमोरलाइज
मैडम
करने
कैसे
लगे
हो
तो
रहा है?
पेटेंट फाइलिंग बंद हो जाएगा.
What I feel is we are only promoting to apply.
I do not
Doing anything
completely agree.
is it?
Ma'am, actually क्या है ना, what I believe is we started seeing the scenario of patent filing since the lockdown began. Actually, let me tell you very frankly, people were not ready. I have been in this industry for last 8 years, and when we started about talking about IPR, people were not ready to think about
Yes.
IPR filing. They were like, ये time waste होता है, इसमें बहुत पैसा जाता है. But when the lockdown came into picture, people had a lot of time to think on it, so they
Yes,
started
yes, yes.
applying, they started getting
Mm.
into this environment, right? And now if we start, they have just started, we have so many people who still doesn't know what IPR is, what actually
Okay.
patenting is. So we will
Mhm.
actually want them to think कि patent filing easy है, then we will talk to them about patent granting, because at least धीरे धीरे उनको चलना सिखाना पड़ेगा, because India has still not reached the pinnacle where people think about patent in everything that they do. When we
Right,
talk
and
about
that's
foreign
true.
country, people at the age of 14 and 15 are talking about patent filing, but here
Patents, yes, yes.
we still don't have that culture, so we have to develop the culture first. And I know there are great people in the research field who feel कि सब apply करे ही जा रहे हैं, सबके नाम पे patent दिख रहा ही जा रहा है, but that is very small count what you're seeing. We still have
Okay.
a far way to go, so we'll have to keep that patience.
Yes, yes, yes. Any questions from students? Any other participants? Can you share the feedback link here, Zuha?
Yes, ma'am, I'm sharing.
Yes. I think during interaction only students' questions are satisfied. I mean, they've got the answer for their queries. That's how they are not typing anything or not asking anything over here. So, with your permission, sir and madam, I think we can conclude today's session. That was a wonderful evening talking to you, listening to you, and your enthusiasm, Pooja madam and sir Swapnil sir is great. Like I am very much thankful to Swapnil sir. Basically, I called him yesterday afternoon, and within 24 hours we are through with the activity. So that's a great speed of how you managed in the 11th hour. I know I should feel, I am feeling very sorry for that because I could not tell you a little earlier. Yeah, I forgot. It's a day to celebrate. We should have done it earlier. We should have gone through the calendar earlier, but because I was busy with some PhD work in the college, I could not concentrate a little in this week about this IPR day actually. So that's great to be with you, and I am very much thankful for your cooperation. Swapnil sir and Pooja madam, if possible, I mean, depending on the schedule of the student, depending on the schedule of academics and examination, we will try to arrange a workshop so that Pooja madam, as you said, or Swapnil sir, as you said, we can actually understand the process of how do we apply, because the students here, I specifically called the final year students here to attend the lecture so that they are in the project completion phase now as per their academics. The term is going to end in the next month, so they are ready with their project work. We have a 1 year project at the final year. So with that ready project, they can think of some IPR out of that. And before graduation, I mean, with the degree of bachelorate, they will have something, at least filed patent in their hands so that they can sell them very nicely in a career boot. That is what I feel. Therefore, I was, in hurriedly, I have requested, sir, let's have it today only. So it was only for 2 hour session. I am very much thankful for that. Next time we'll have a little more interactive session and we'll do it in a small groups so that let them go through the entire process. I mean, you guide them which website to be followed, what is the format of the form they have to fill in. So it will be a kind of practice session we will arrange for the students, a kind of hands-on, what we call it, as we'll arrange for the students so that they'll be more motivated to create the IPs for them. It is benefited for their career. For college, it's okay. It's a side product, I would say. For them, it's a value added biodata. Throughout their life, they will be carrying it. So
We are
that's
just a phone call away, madam, for that things. We are just a phone call away.
yes, sir.
If
That is what I
anyone need
realized
assistance, we
yesterday.
are
We
just
talked. Yesterday we talked, and today we are through with the activity. So that's how your cooperation level is. And today also, students, there was little confusion between the time. I thought it is 5 to 7, but sir was under impression 5:30 to 7:30. So the jugglery we managed between 4 to 5. Students do not know what happens behind the curtains. So sorry to both the experts of today's session. That was a great having you with us from Government College of Engineering Aurangabad. I am very much thankful to you, and I'm happy to develop a interaction like this onwards also. Of course, the academics and examination schedule and all, we being academics institute, we have to follow those. So with that, I think we can arrange it next time for PG and PhD students and faculty, a little higher group that will be more interactive, and that these are second year students.
if we start from second year, madam, it will be easy for them to understand, and they can process it for the whole of the year, because they have time to process this information, all these things.
Yes, definitely. I'll let you know, sir, whenever suitable and as per the academic schedule in the campus. So thanks a lot.
Thank you, ma'am.
Thank you, madam.
Thank you.
I'm thankful to Dr. Kahalekar sir, who is principal. Anjali Bhalchandra madam, she's here all the way. She was cooperative all the way, because with her permission we could proceed for this particular event. It was on 11th hour management, so everyone cooperated a lot from our side also, and of course you two are always there. So, and students, they have also with quite a short notice they have joined us. So we are thankful for everyone for this particular event. Students are requested to complete the feedback form over here, which is shared in the chat box. And I hereby, with Swapnil sir's permission and Pooja madam's permission, Bhalchandra madam's permission, and all the faculty members who have joined here with their permission, I declare that the session is over. Thanks once again. Yes,
Thank you, madam.
Yes, thank you, sir.
Okay.
Thank you. And students are requested to complete the feedback formality and then leave the meeting. Thank you. मुलांना फीडबॅक फॉर्म भरा आणि मग जाऊ शकता. क्लिक केलं की तुम्ही फीडबॅक फॉर्म गुगल फॉर्म ओपन होईल फीडबॅकचा.